I'm going to talk about accounting fraud, financial accounting fraud, disclosures, Foreign Corrupt Practices Act by stock issuing companies. So to the extent that insider trading, market manipulation, those are the easy cases. These are the hard ones. So let's just go ahead. I think I've got like 75 slides, so if I do like half a minute each, we'll be good. So it's important to understand how a company falsifying its books actually results in a securities law violation, right? And the concept here is that issuers in the United States have an obligation to make certain reports. They have certain forms, certain filings that they have to make. This lists them. We're talking about initial public offerings. These two are the big ones for me, the 10K and the 10Q. Annual reports, quarterly reports. Okay? So there are things that are specifically called for in those reports. They're in the regs. You can look at those as well as I can. But they're supposed to report out on the company's business, how it's doing, right? It's supposed to report out on the accounting assumptions that they've made, the rules that they're supposedly following. And the key here is you're not allowed to lie on those forms, right? The things you say are supposed to be true, okay? They have disclosure obligations, and those disclosures have to be made truthfully. And that's really the crux of this whole concept. If you were on a cash basis for accounting, where you just count dollars in, you count dollars out, and that's it, it'd be very simple. There'd be very little room for this kind of chicanery. But it's not that simple, right? It's accrual-based, and there are lots of different rules for accruals, and when you can recognize this, and when you can recognize that, and you need to, one, say what rules you're following, and two, abide by those rules, right? So this is an S1. This is an initial public offering form. I'm not going to spend a lot of time on that. This is a 10K, annual report on 10K. This is the quarterly report. This is the 10Q. Right? You also have something called an 8K, which is something big happens. The company wants to report out on it. It's material information that it wants to get to its investors, so it does this. This is basically like you have a press release, you stick it on Form 8K, you're good, right? So we were talking earlier about, I was talking with someone, I've forgotten with whom, about disclosing certain material events of a company to certain individuals, but not the entire marketplace, and sort of the inequalities there. We have a regulation, FD, that sort of says if you're going to disclose material information to the marketplace, you have to do it to everybody at once. This form is the way that those companies guarantee that they have complied with that. All right, so what needs to be disclosed in these reports? These things, right? They don't usually lie about the history, right? They don't usually lie about their business overview, right? Where they will lie is in here. How much money they're making, okay? You'll have these slides, so you can go back over them and read them at your leisure later. There'll be something called MD&A, right? That's the first thing. That's where it's supposed to be what says it? It says it. Management's discussion and analysis. That's supposed to be a plainer English description of the business and what's going on. It can still tend to be pretty legalistic because lawyers are invasive, right? They're an invasive species. Those things. All right. So companies in the United States, issuers that are public issuers, have to file these disclosures. Those basically set out the rules, right? Those set out the baseline. Those are the representations that we can evaluate. Like everything else, not everybody tells the truth. So this statute, Section 10B of the 34 Act, is the bread and butter fraud provision. Don't lie, cheat, or steal. That's what that says. It's got a lot more words, a lot more flexible. But the advantage of this is a malleable statute that allows you to attack a lot of untrue, a lot of deceptive was the word I couldn't find, a lot of deceptive conduct, right? It's a flexible provision. It doesn't say, it's very broad, right? There are other provisions for other statutes that prohibit you from committing fraud. Another area, other statutes that are potentially applicable are these two, the books and records and the internal controls provisions of the Exchange Act. So the thing about fraud, right, the fraud provision, that last one, right, I have to prove an intentional misstatement, not an accidental mistake, not misstatement, not negligent, but actually intentional, right? You lied, you meant to lie, right? That's fraud. But there are a lot of other things that don't arise to the level of fraud that we'd like to prohibit or like to insist upon. And so these two sections require issuers to have books and records that reflect their business. Kind of makes sense, right? And we also require them to have internal controls, internal accounting controls. These are not scienter-based. These are not intent-based. These are not mens rea-based. You can accidentally, negligently violate these. It's kind of hard to accidentally not have books and records, but they might be inaccurate, right? So that's important. It's in a lot of regulatory or law enforcement regimes, it's nice to have tiers of offenses, right? For one of a better analogy, murder 1, murder 2, manslaughter, assault, covering a lot of different misconduct, right? You don't just have one prohibition at the top that covers the worst misconduct and then let other lesser misconduct occur and have no sanctions, no prohibitions for that. So this covers those. Pretty cool.
Which is the majority of compensation for officers and directors.
And remember, it's also these things happen. There's a triangle, and there was the opportunity, and there was the incentive. Those payments are the incentive, right? The bonus. That's generally why people want to commit fraud. We like it when accounting records are intentionally falsified, misrepresentations made. So I've covered some of these. Internal controls matter. Where's the thing I want? These are, all right, these are papers you can get from different parties in terms of investigating. Here's channel stuffing. This is channel stuffing. That explains that. Foreign Corrupt Practices Act. I had to hurry up and get to this for Aaron. All right, the Foreign Corrupt Practices Act makes it illegal for a company that is issuer in my country to go bribe someplace else, okay? If you're going to be, there are a lot of requirements to be in my marketplace. You've got to file the forms 10Q, 10K, have to hire an auditor, have to do this, have to do that. You also don't get the bribe, right? So that's one of the justifications. You can't make corrupt payments to foreign officials. Also requires publicly traded companies to maintain certain record-keeping and accounting practices. Remember back at the beginning I said fraud, 10B, right? And then I said, here's some other sections, section 13A and 13B, books and records, internal controls. If a company bribes someone, they rarely account for it properly on their books and records. You will rarely see journal entry that says, bribe to government official, right? And that's a violation of their internal controls. That actually makes their books and records not represent their real business. I mean, it seems like it seems like getting, who's the Chicago mobster during Prohibition? Al Capone. It's like getting Al Capone for taxes, right? But we got Al Capone for taxes, and it solved that problem. So maybe that's like that. What's that? That's enough? All right. That's stuff you can read later. We do a lot of stuff. The DOJ and the SEC have their own missions, their own things. We talk, but we don't. We're independent. Those are things you can look up later. You can ask Aaron about that. I said that. Thank you.
So I'm going to be doing a bit of a deep dive in the investment company regulation. We did the advisor regulation yesterday. There are some slides I'll go through very quickly or skip because we've kind of covered them, and there are a couple of things that I really want to focus on, give you more information on. So with that, this is just the agenda of what we'll cover. What's an investment company? Investment companies are really cool. Investment funds are just awesome. They are a way for any investor, regardless of how much money you have, to access the markets. And to access the markets in a diversified way and be able to have their assets managed by a professional. So the capital markets are just phenomenal, and this is a way for anybody to access them. We have a pretty broad definition in the Investment Company Act to capture any kind of entity that could be an investment company. And our test for it, and it's statutory, there are two of them, it's subjective or objective. Subjective one is just what it says. If you're an issuer and you hold yourself as an entity that invests, reinvests, or trades in securities, you're an investment company. The objective one looks to the portfolio and how many investment securities you have, and 40% is the cutoff. The objective one is an interesting one because there are many cases where you could just trip it up. You are doing a type of business where you hold a lot of securities, or you do an offering and you end up tripping up the 40%. In a lot of situations, several times a year, actually, our division of corporation finance would call my division and say, I have this issuer, I'm reviewing the 10K, and I'm looking at the financial statements, and based on just a pure math calculation, they're hitting 40%. So they send it to us and we look at it. And what we do have, and that's by statutory authority as well, we are actually able to make a determination. We give those people exemptions to say that they are not investment companies. And there are a lot of companies operating out there that need this from us. Yahoo has an order from us, Google, Dolby, the sound system company, a lot of IP companies that sort of license a product and all they do is have this IP right. They're not producing something, but they make so much money because they're licensing that and then they invest that money. They are not an investment company, but they have so much investment securities on their books, they trip it up. So we can make a finding that they're not engaged in the business of being an investment company. Of being able to do that, it's actually really significant because if we don't make that finding and they become a registered investment company, they have to be regulated by us as an investment company. They are subject to all the prohibitions of the Investment Company Act and the disclosure regime of the Investment Company Act. They would need to get an investment advisor. They would need to have a compliance program. They would not be able to be an operating company if we're not able to tell them it's okay.
No, this is clear, but the 40% is the threshold?
Yeah.
And if they exceed that, they're going to have to be regulated by you?
They don't have to be regulated by us. So if they exceed that, there's the question. And either they can come into us and to be 100% certain, go through the process of getting what I call a 3B2 exemption, an order from me. So they could do that. Or some of them, like I recently had a conversation, if any of you have ever worked in the United States for a private company, there is this one company that does the checks, for the payroll checks, ADP. It does like all the checks for all companies in the United States. And because that's what they do, they're a payroll processor, all they have is cash. That's all they do. Their business is cash. And so my division of corporation finance called me up and they're like, we're looking at this company, over 70% of their assets are investment security. They trip up the definition. Well, all I did was call up the company. I had a nice conversation with their general counsel. And he was like, yeah, we've looked at it, we understand, but we don't hold ourselves out as an investment company, the subjective test. So they went through the process, and they're allowed to do that. You can go through the process as a company and say, you know what, I am an actual operating company. I don't hold myself as an investment company. I don't invest, reinvest, and trade in securities. I'm not an investment company. I got my private lawyer to write me an opinion. I'm good to go. And in that instance, I agreed with them that they're not an investment company. The statute does exclude or provide exceptions from the definitions for particular types of entities. The first two we covered before, 3C1s, 3C7s. Those are investment companies, but for the fact that we give them an exclusion. But these are the private funds. The others are entities that could trip up the law, but for those exceptions, like underwriters, banks, charitable institutions, those are all excluded from the definition of an investment company. So in the subjective, it's not an issuer that's engaged or does not hold itself out, and it's not engaged in the business of holding securities. It is a holding company of operating companies. On the objective test, even though it might trip up to 40%, there is a specific exclusion in the statute itself. So if you are a holding company, and you look at not just at yourself, you look at your majority-owned subsidiaries. So if your majority-owned subsidiaries are operating companies, you can ignore the fact that you're essentially holding their securities, because that's all you're holding, right? The equity of your subs. So a little bit of a deep dive on some of our investment companies. Just to give you a sense, this is as of our last fiscal year end, and our fiscal year end in the government ends September. So as of that, we had just under $18 trillion of assets in investment companies, and that was just about 15,000 funds and registered portfolios with us. No, that's just registered and regulated. BDCs are called regulated, not registered. Let's go through a few of them because it's kind of interesting to look at them. Open-end funds, you can see by the number, 12.3 trillion. Obviously, these are our biggest types of registered entities. All pension plans, if you've heard of 401ks, that's what they invest in, so that's the bulk of money coming in. You know, pretty much any U.S. regular investor, that's where they go. They issue what we call redeemable security. That means that I have the right to go to the fund. When I give them my shares, I get my portion of the assets of the fund. It is not subject to market fluctuation, other than obviously the price of this portfolio securities could be, but I get my share from the fund. We do say investors transact directly with the fund because of that, but keep in mind that most investors in the United States go through a broker, and they pay the loads by doing that, but they do transact directly. Their relationship is with the fund. They are the beneficial owner directly with the fund. Continuous offering, they register an unlimited amount of shares with us at the SEC, and they're always just offering securities in that fund. They have a board of directors, and they are managed by an investment advisor that's registered with us. ETFs, that's my specialty, about 1,600 portfolios. $2 trillion of assets under management and growing. It's one of our biggest segments of new products that's growing. Typically today, they are open-end investment companies. However, the very original ETF, Spiders, that was a unit investment trust. We don't have anybody coming in asking to be a unit investment trust. It's pretty hard to have an ETF that's a UIT, at least current ETFs, because UITs are not managed portfolios. So no one does that anymore. There are benefits to being an open-end structure. It's a hybrid structure. It's like an open-end fund in many ways, but it also combines what we call closed-end funds, which I will cover, and closed-end funds are trade on one of our national securities exchanges, as do ETFs. So ETFs trade on an exchange. As an investor, me, if I want to invest in an ETF, I have to go to an exchange and buy shares as I would buy of IBM, Apple, whatnot. But there are certain investors, really, really, really big broker-dealers, we call them authorized participants, that are able to transact directly with the ETF in bulk. And as of today in the United States, most of the assets that you see up there, the $2 trillion, they're index-based ETFs. We don't really have that much in the active space. The reason being is that our current regulatory regime requires full transparency. And as you can imagine, if you think yourself an active manager, you think you got some kind of secret sauce, you're alpha, and you don't want to put that out to the market by, making your portfolio public. And so as of right now, we have very, very, very few active, and they tend to be fixed income, because in the fixed income, it's kind of, really, even if you have some kind of alpha, it's hard to front run you. Front run is trade ahead of the fund, because it's really hard to trade in the fixed income markets. But we don't have equity active ETFs. I had mentioned that, so data gathering, those are the two forms I mentioned, and send and port. Part of that as well is an idea of whether we're going to do any electronic shareholder reporting. I don't know if you're in jurisdictions, paper or electronic filing, but that's a current debate, if you will, that we have in our jurisdiction. Liquidity is one we are trying to tighten up. We did put a proposal out there that will require all open-end funds to file with us classifications of their assets, as well as have a liquidity risk management program, and have a designated officer to manage that programs. We love sort of compliance programs. So that one is in the proposal phase. Again, the commission has not yet moved on it.
So as we've been talking about securities fraud, money, transactions, people, bank accounts, they all, located all over the world, can reach out very easily into other jurisdictions. For us at the U.S., we have a lot of people that are all over the world interacting into our securities market. They can, by a click of the button, buy securities in the U.S., and another click of the button, they can transfer their money overseas. So there are lots of different frauds that involve people that can be in multiple jurisdictions. So for example, broiler rooms, which Matt talked about, where you have army of salespeople picking up the phone and high pressuring customers that could be all over the world to buy securities. For a long time, 80s, 70s, 80s, 90s, they were in the U.S. And once they realized that we can actually get at them in the U.S., they went abroad. And setting up the schemes in different parts of the world also allows them to further evade law enforcement, further evade our efforts. It takes us a lot more time and energy to be able to track them down, track down who's behind the corporation, who's behind the phones, who's actually the salespeople, where the bank accounts are, where the information is. And so it slows us down because as national regulators, our powers stop at our borders, but they, through the internet, have very easy access to all sorts of different versions of technology that allow them to reach across borders. So IOSCO principles, I'm actually not going to talk about this for the most part, because how many people are familiar with the IOSCO principles? See a show of hands, a lot of regulators. What about anybody in the room have done an FSAT before or something sort of like, yes. So now that we're all subject to FSATs, we're actually very painfully aware of the principles, which are really a great international guidepost for us and a great way to sort of think about our powers. The principle 10, 11, and 12 go to inspections and enforcement. And so principle 10 is regulated entities, and do you have the powers of obtaining records from them? Principle 11 is enforcement powers. Do you have the ability to compel documents, evidence, witness statements, telephone records, ISP records, the things that Matt has been talking about all week? And then principle 12 sort of feeds into both of those. Do you use these powers credibly? Are you able to use your powers to properly inspect and supervise your regulated entities? Can you compel information from any person that might be manipulating your market in your jurisdiction? And do investors know how you're using those powers and how you're actually protecting the market? 13, 14, and 15 are all international sharing. So those powers that you can do for your own market, can you do those to obtain information and or get information from regulated entities? Can you do that for others, and can you share that information? Really, the important thing is to make sure that your counterparts are able to give you information that might be important for your investigations and or your inspections. It's really important to be able to have those powers for yourself, but also have counterparts. So if someone is hiding in their jurisdiction or located in their jurisdiction and misusing your markets, that you can get access to that information, figure out who's behind it and what type of activities are taking place on your market. Taking witness statements and testimony is another great benefit of the MMOU. So signatories that sign on, if they have the power to obtain and compel statements, they will let you know. It's a voluntary power, but every questionnaire, every verification report, verification team report that IOSCO does for every single signatory will ask, can you take testimony? Can you take statements? Can you share those with others? What's the protocol? There's kind of a wide variety of different ways that jurisdictions take statements or compel statements or testimony. In the U.S., as I think you've heard from Matt, we subpoena a witness. It can be any witness in the United States. They have to come in, they take an oath, and they have to answer, and then they answer questions. Now, they have to be there, they have to sit in that seat, but they can say, you know, on advice of counsel, I'm not going to answer because of my Fifth Amendment right against self-incrimination. So that is their right in the U.S. to sort of say, I'm not going to answer. Some other sort of former Commonwealth countries, they have a different approach on self-incrimination where they can compel a witness to come in. The witness has to answer questions, but then that transcript or sworn statement can't be shared with any criminal authorities. And so it's important to know, if you're asking for testimony from your foreign authorities, what privileges they have in their jurisdiction, if it's under oath, what's the typical way that they take testimony. Can you be present? Can you ask questions? Is it just a written statement? So it's a lot of questions to ask them. Another way that you could have assistance in the MMOU is when you're litigating. And there's a lot, once the SEC staff investigates and decides that there's a violation, makes a recommendation to the commission, and initiates an action, that's not always the end. Because then we have to litigate against the defendants. And some of them may be in foreign jurisdictions. So we have to give them notice of the proceeding. Many times their foreign counterparts can help with that. Other times there may be a separate treaty or convention that you have to use. Depositions and discoveries. So we need to get information and evidence from witnesses that relate to the trial that our foreign counterparts may be able to assist us with. Certifying documents, so you have to have a custodian in the U.S. say of the documents, say that yes, these are documents kept in the normal course of business. I'm certifying that these were our records that we provided or produced. And then enforcement of judgments. So if you sue somebody in your court, you get a judgment. Can you go and enforce the judgment? Can you actually get monetary penalties? Can you get disgorgement? We've looked at this issue a lot for our own purposes, and we've found generally courts may enforce disgorgement because it's an equitable remedy. It's going to be paying back investors. It's ill-gotten gains of investor proceeds. But generally they won't enforce penalties because that's considered a criminal sanction in some jurisdictions, or it's a penal sanction, and many times you may need a separate treaty with a country. So given how much information is dispersed throughout the world with the internet, with bank accounts all over the world, you know, the importance of us working together, having our compulsion powers, and being able to share really allows us and you to be able to further oversee your markets and go after bad behavior. So I want to make sure I don't have any, do you have any questions? So let me try the video one more time, see if this works.
But we're one of the few organizations within the agency that actually goes out and does exams, and we're considered the eyes and ears of the commission. We end up having a lot of cooperation internally in the agency, particularly with divisions and offices such as Matt's division, the Division of Enforcement, as well as Dahlia's division, Division of Investment Management, as well as, I said Matt represents Division of Enforcement today, but also the Division of International Affairs and Office of International Affairs. And so one of the things that, we assist enforcement in enforcement investigations, and we give them referrals. Around 15% of our exams end up being referred to the Division of Enforcement, and our examiners often help support the enforcement investigations as well as any actions that they bring, sometimes testifying on behalf of enforcement as to what we found in the field. We also supply a lot of intel and information and informed policy by sending our findings and certain trends that we're seeing to the Division of Investment Management, which is where Dahlia it represents today. What we do is, if we're going out and doing exams of investment advisors and investment companies, we'll often have findings, and especially if it's cutting edge changes and things that we're seeing in the industry, that there may be a disconnect in the rules that IM is interested, investment management's interested in working on. And we can provide them information. And so, I did want to emphasize that internally we work with a lot of divisions and offices as well. But externally, OC has a number of ways that it works with other agencies. From a criminal perspective, that's I showed a diagram in my risk discussion of the pyramid of the different regulatory schemes of the United States, and the criminal folks with the Department of Justice was at the top of that pyramid. We work primarily with the criminal authorities at the SEC through the Division of Enforcement. There is some interplay with the exam program, but not near to the extent that it is in the enforcement division. And so we work very little in the criminal space. We may testify occasionally in fraudulent matters, and if it's a serious fraud and it's expedited, our examiners may have key information and be fact witnesses for the criminal authorities. But typically, that relationship is held by the Division of Enforcement. Where the exam program works is more with the regulators that have examiners of their own. So for instance, with the Department of Labor in the United States, they regulate basically pension plans and pension firms that play in pension funds. And so one of the things that we tend to have some overlap with those regulators, particularly if we're doing an investment advisor that also advises pension funds. So if we find illicit payments to board members, if we find some sort of activity that we feel, it may or may not be a violation of the securities laws, but it may be a violation of ERISA, which is the Employee Security Income Protection Act, Retirement Act. And we end up working with them to give them information. We have a MOU, a Memorandum of Understanding, where we can supply them with documentation. And that's something that we do occasionally work with the Department of Labor. We also work with the Commodities and Futures Trading Commission, the CFTC. And this is typically when we notice that a lot of, particularly private fund advisors, are duly registered with the SEC for securities transactions and with the CFTC for commodities and futures transactions. And they have an exam program as well. And so we work with them in sharing information, particularly if there's something that we're finding that may be fraudulent, maybe misappropriations from by the advisor or by the advisor personnel from client money. And so we'll work with them on trying to solve those issues and work together to get jurisdiction to see both sets of activity, because we're typically not experts in the commodity space and they're typically not experts in the security space. So working together with both sets of legal platforms is critical to getting to the right answers from a regulatory standpoint. We also work with the Federal Reserve often. One program in particular within OC is one that regulates the systemically important clearing agencies. And these are the big firms that clear, the bulk of the securities transactions in the market. And that team, the Fed Reserve has examiners that are also in the clearing agencies on a regular basis. And so that team works together with the Federal Reserve often and regularly. I think they meet every 2 weeks to discuss ongoing exams. And so there's a lot of coordination there between the Federal Reserve and the exam program. We also have a lot of regular meetings with the Fed Reserve on large banking umbrella companies. And what I mean by that is large banks often have both banking segments as well as brokerage firms, investment advisors, and sometimes even mutual funds, investment companies. And so a lot of times we're having discussions with the Federal Reserve where the Fed is assessing the financial stability of the organization, of the banking organization, and we're assessing the compliance with the federal securities laws with the registered entities that are owned by that banking holding company. And so we have discussions on a regular basis with them about some of the largest banks that own and play in the securities markets and have broker-dealers, investment advisors. In terms of state securities regulators, we work a lot with the states. Most states, there's 50 states in the United States, most of them, I think all but one, have their own state securities regulators. And we coordinate with them on a regular basis and meet with them on a regular basis if we're seeing transitions of what they may have found to be a difficult registrant moving from a state level to a federal level. And that's based on size growth typically, where a state registered advisor typically has a less than $150 million in assets under management. And once that firm exceeds $150 million in assets under management, or they start an investment company, they'll click over and register with us, with the SEC. And so we have good relationships with the states where they can give us the heads up if somebody they feel is a bad actor or has concerns about their compliance programs. And likewise, we may do an exam of an entity that wants to be SEC registered because they're able to use that it lends to more credibility when they're trying to obtain clients, particularly institutional clients. And they may say they're SEC registered, but they're really not eligible. And so sometimes if we identify a firm that should not be federally registered, it shouldn't be registered with the SEC, but should be registered with the state, we'll let that state know what we found. And we have memorandums of understanding with all of those states that have state regulators. That's something that we work with them quite a bit. We also have just regular ongoing meetings about risk and what they're seeing and what some of the challenges they face. We also do joint training with state regulators. That's something that we found to be very effective. How do we have, I guess, like procedurally, how do we have this interagency working? Well, I mentioned a few times, we have MOUs with the bulk of these entities that we work with. There's standing agreements where we share specific information, and there's certain conditions that are put on the use of that information depending on, most of our exams are non-public, and so we have pretty strong constraints on being able to disclose information that may be non-public, and it's typically only pursuant to a legal action. But it is something that we have a pretty detailed agreement that we put in place. Sometimes it may be on a matter basis as opposed to a long-standing relationship. Certain agencies, we may have access request letters where they agree not to disclose certain information, in terms of if it's non-public. We even have, relationships sometimes as an agency, and Matt will probably address this, with the Food and Drug Administration. There are some FDA matters that we work jointly with our enforcement group. So, you know, in terms of the self-regulatory organizations, there's two main ones that OC deals with. One is FINRA, which, you know, as I previously mentioned, FINRA regulates the broker-dealer industry, and it has approximately 3,500 employees. And so, you know, they do a nice job about regulating the broker-dealers. And some of the things that we've had some changes with is because OC only has 1,000 folks or so, and FINRA has 3,500. What we've noticed is the coverage on broker-dealers from an exam standpoint is about 50% annually. Another link that's on our website, and you can see what we found. It's about 8 pages worth of findings on the readiness in the range of readiness of different firms. You know, we've initiated phase 2 of that cyber exam where we're doing deeper dives. But I think this, too, is another example of how we're promoting innovation in the markets, particularly from a cyber perspective, which, frankly, is an international, worldwide issue that I think will be here for a long time. So trying to get people to think about it more outside the context of an enforcement action or an information loss of client information, I think is important to help improve readiness. So with that, I will stop and turn it back to the panel. Thank you.